Matt Benedict, and I'm back with another video. No one was hurt, but I am charged with domestic violence in Michigan. In this video, I'm going to talk about how this happens under our laws in Michigan. So let's get started. Michigan groups two different crimes together under one roof. Really, an assault and a battery are two different crimes. But under Michigan's laws, we kind of group them together because they are so connected to each other. There are two paths in which to get to a no injury case. The first one is A, as a battery. People don't understand what a battery means. A battery is broader than most people think. B, a purely assault factual pattern. In this video, I'm going to talk about A. When I am defending a person for assault and battery, the first thing I do is dive into the police report to determine if we're dealing with a fact pattern that addresses a battery or if we're dealing with a fact pattern that is purely an assault in nature. I am going to use the Michigan Model Criminal Jury Instructions to explain how someone can be prosecuted for a no-injury battery. Now, if you ever want to look at jury instructions in Michigan, go to Google and type in Michigan Model Criminal Jury Instructions. The Michigan courts publish model jury instructions. These instructions are used by almost every district court across Michigan. So if you ever want to plan for defense against a criminal charge, it's always important to pull the criminal jury instructions and read them. That will allow the attorney and the client to formulate strategies to defeat this charge during litigation. Now let's take a look at the jury instruction for domestic violence in Michigan. This jury instruction is what the judge will read to an impaneled jury before they go into deliberation. The defendant is charged with domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered the victim. A battery is a forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against the victim's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make the victim reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability, or must have thought she had the ability. Second, that at the time the victim was the defendant's spouse, or was the defendant's former spouse, or had a child in common with the defendant, or was a resident or former resident of the same household as the defendant, or was a person with whom the defendant had or previously had a dating relationship. Okay, so now let's break down this jury instruction. First thing I want to call your attention to is right here. Forceful, violent, or offensive. What exactly does that mean? Jury instructions include a definition of this. Here's the definition of force and violence. As used in these instructions, the words force and violence mean any physical force against another person so as to harm or embarrass him or her. Returning now to the domestic violence instruction. The second thing that needs to be pointed out is this line here, something closely connected with him or her. Classic law school example of a battery involving something closely connected to him or her is someone walking up to a person on the street. They get into an argument and the perpetrator reaches over and flips off the hat of the victim. A modern example of the same idea is someone slapping a cell phone out of the victim's hand. An offensive action against someone's cell phone, particularly if they are holding that cell phone, would be offensive touching of a person or something closely connected with him or her. The next section of the DV jury instruction that we need to take a look at is right here. Touching. For a battery to occur, the touching must have been intended by the defendant, that is, not accidental, and it must have been against the victim's will. It does not matter whether the touching caused an injury. Here is the key point to take away from this jury instruction. Injury is not necessary. I have to explain to a lot of people the prosecutor does not have to show or prove an injury to the victim. However, it is always better or easier for the prosecutor to secure a conviction when there is an injury present. If I read a police report for domestic violence and I do not see a physical injury documented within the report, I immediately start to think that this case will be triable, that I can win this case at trial. The second important point to take away from this definition of touching is right here, not accidental. Some examples of accidental contact would be a couple arguing in the kitchen and the wife steps on the husband's foot. Another example would be a couple that's arguing and the dog comes in and the husband falls over the dog, collides with the wife, and she gets a bruise from hitting the wall. Those are some fact patterns in which you could argue that the battery was accidental. All right, now that we have looked at some supplemental jury instructions to help define the meaning of a battery, let's try to put it all together. Here is the wording from the instruction with the included information that we just talked about. Okay, so let's look at some examples to help illustrate what we just looked at in the jury instruction. Number one, boyfriend pours beer on his live-in girlfriend and threw the empty beer can at her. No physical injury. This would be a battery because the physical act was designed to embarrass the victim. Number two, slap a cell phone out of a person's hand equals a battery because the phone is closely associated with the victim's person. In addition to committing a battery by slapping a phone out of someone's hand, there's also an additional charge that Michigan has created associated with preventing someone from calling for help. You often see that charge in addition to a domestic violence charge. Number three, live-in girlfriend kicks boyfriend out of their house. The girlfriend follows the boyfriend around yelling at him. A lot of times people will want to have the last word in an argument. The boyfriend picks up all his stuff, packs his bag, etc., but he bumps the girlfriend in the doorway as he is leaving. Now, did that boyfriend intend to commit a battery, or was that an accidental contact? And finally, why are seemingly minor offenses being prosecuted across the state as domestic violence? Factor 1. Domestic violence is a hot topic for politicians. Politicians always use hard-on crime to achieve votes. Number 2. Domestic violence is one of those crimes that continues for many years and gets worse over time. Intervention can break the cycle. The courts and prosecutors have picked up on this, so they're always looking to intervene as quickly as possible. Number 3. First offense DV will likely be offered a sweetheart deal in MCL 769.4a. This sweetheart deal in MCL 769.4a is a deferred and dismissed plea offer. Essentially what that means is once the person accepts this plea deal, they'll be placed on probation and have to go through some vigorous anger management courses designed to educate the defendant on their personal anger issues and prevent reoccurrence of domestic violence. It is a sweetheart deal because at the end of this probation, the defendant will not have a criminal conviction. Many of these domestic violence cases can be litigated and won at trial. Jurors, in my opinion, have a little thicker skin than most of the prosecutors. What I mean by that is they don't like government intervening and coming down on people for seemingly minor offenses. Thanks for watching my video. Please like and subscribe to my channel. I will put a link to my website and blog in the description of this video. Thanks again.